So like before, we're going to proceed with the question and answer. I'm going to start here. It came up, people who have criminal charges, who feel like, even though they're criminally charged, that they were assaulted in the process, if they can sue the police, and when that process would start, because if you have criminal charges ongoing, when can you actually begin the process of suing the police? How does that work?
The fact that you have criminal charges laid against you doesn't stop you from suing the police, certainly. And in fact, it may give you another ground to sue the police if the charges against you are being pursued maliciously. It's called malicious prosecution. The police have to have reasonable grounds to lay criminal charges against you, and if they have or ought to have knowledge of your innocence, they ought not to be pursuing a case against you and should be taking the steps to make sure it's not pursued. The question of when to sue the police for a malicious prosecution type claim, there's been some conflicting case law. Generally, you'd still want to bring it within 2 years of most incidents that occur to you. So if the charges were laid in June 26, 27 of this year, then you'd probably still want to bring them within the 2-year limitation period. You don't want to be fussing with the argument about whether a malicious prosecution claim can be brought from the date the charges were actually dropped. If you want to bring a malicious prosecution claim, you do have to have the charges against you do have to be resolved in your favor. In other words, if you're found guilty, then you don't have a malicious prosecution claim. But if the charges are dropped, if they're stayed, if you're found not guilty by a court, then you may be able to make a malicious prosecution claim. But you can start the claim for malicious prosecution before that conclusion. You may not be able to pursue it until you have that conclusion.
I just wanted to clarify a point that Vilko raised, and I assume it was what Eric said, but maybe it wasn't. Usually the thing is you're included in the class action, and if you opt out, then you can do your small claims thing, and they won't stop you from doing it. But that's good to check on that, but that's our understanding. So if you want to do the individual process, you can, but that means you then, if there is money at the end of the day for the class, you don't get it. To let everybody know that there is if your income is less than $1,500 a month, they ignore the $175 fee to do the process, and she said she finds it to be relatively straightforward. Just to close off this section, as Rob, I think Rob who mentioned that if there is interest, and you can display your interest at the back or via email to us at lawunion.mdc@gmail.com. If you have an interest in doing a focused workshop on suing the police, the processes, someone to have people who have done the process go through it with you, we can arrange that. We're willing to do that. We can set a time and do that in an evening or an afternoon, but just let us know if that's something you're interested in doing. And Vilko.
One last thing, the Law Union, along with several lawyers and organizations and committed volunteers, have been putting together a written guide for that gives a lot of the information that you've heard today, but puts it in a written form, and as well as some information about what rates you have. The expected date for that will probably be in about 2 weeks' time, and you can check the website of the Law Union of Ontario, which is www.lawunion.ca, in about 2 weeks' time, or it'll probably be also on a number of other organizations' websites. I assume AMDC and other organizations will have that posted as well. So you'll have more information in a written form coming out fairly soon.